Thank you. Hello and welcome everyone to Dr. Bahri's book launch, Public-Private Partnership for WTO Dispute Settlement Enabling Developing Countries. I'm honored here today to welcome all the participants and panelists who have made this possible. Today, Dr. Bahri presents a new perception of the legal capacity of developing countries in the international trading system. Now, as you can see in your program, we will have different comments, notes, and opinions on Dr. Bahri's new book. First, we will have a welcome note by Dr. Jorge Serdio that we will officially launch the book. Afterwards, we have many participants tonight that will be commenting on the book. By the end, Dr. Sofia Charbo will officially close the book launch with a vote of thanks. Nevertheless, folks, that's not it. We'll be having cocktails after the closing vote of thanks. Everyone is cordially invited to join us. All right. Today we have the pleasure to have Dr. Serdio, who is the Dean and Head of the Law Department at ITAM. We also have the pleasure to have Licenciado Fernando Mateo, who is the Director General of the Evaluation of Economic Policies. Unfortunately, Professor Gregory Schaefer wasn't able to come, but we will have a special connection through Skype. We are very grateful to have Professor Henry Gao and for traveling from very, very far away for this event. We also have the pleasure to have Licenciado Mateo Diego Fernandez, who is one of the founding partners of Aegon Law Firm. We also have the pleasure to have Professor Bradley Condon, who is a chair of WTO Law at ITAM. We have the pleasure to have Professor Gabriel Gary, who comes all the way from UK. And finally, we have the pleasure of having Doctora Sofia Charbel, who is a leading authority in the field of public health law. We thank you all for coming here today. Now, I have the pleasure to introduce our Dean and Head of Department, Jorge Serdio, to the podium to present his welcome note and introduce the book as well as the author. Dr. Jorge Serdio is a law graduate from ITAM and received a PhD from University of Buenos Aires. He is the Director of the Center of Access to Justice. He is also a full-time professor at ITAM and has been a member of the Executive Committee at the International Association for Social and Legal Philosophy. Please welcome Dr. Jorge Serdio.
Thank you. Good evening, everyone, and welcome to the launch of Professor Bahri's book, Public-Private Partnership for WTO Dispute Settlement Enabling Developing Countries, that has just recently appeared, published by Elgar in the UK. I would like to first especially acknowledge the presence and welcome of our special guests and commentators for the book. And then I would like to say a few words about the author of the book. And a scarce remark perhaps about the work itself, since I am not an expert in the WTO law. Formally, from the profile you can read in our webpage, you will find that Amrita Bahri had a binational education in India, where she received her LLB from the University of Delhi, India, and in the UK, where she received her master's degree in LLM International Business Law from the London School of Economics, and her PhD in International Trade Law from the University of Birmingham. But behind these labels, you will find an individual with tremendous appetite for big challenges, I would say. For example, to run and have been elected to the largest student body in Asia during her time in the University of Delhi, or to apply and being awarded the single Chevening Scholarship for Legal Studies in India, or being a founding member of the Center for Legal Skills and Methods at the University of Birmingham. She takes upon big challenges, I would say, all of them with unsurmountable results, and with that tenacity that is rarely seen among young scholars. I think these challenges, all of them, could have not been achieved without her skills, determination, and the ability to work well with others. The book we are launching here is yet another example of a challenge, well faced, and with great results. It is a research that recollects data from key actors in the national level that is not easy to harvest at any point, and it proposes a diagnosis for the local institution capabilities to face global trade challenges using WTO law, and suggests possible routes to enhance the stance of emerging countries. This not only shows determination, but a great deal of skills, which it really shows in the insights of the book. It is for sure a relevant work that deserves the comprehension and will advance the comprehension of the relationship between a normative system, that is WTO law, and I would say the pragmatics of that system. The use, the stances and positions that different users of said normative system have towards those normativity. Different users, countries, will take better advantage of the system to serve their interests, in part because of the resources they have. In this, the book entertains a thesis that is well known, that is that intellectual human resources and economic resources make the difference in any legal case. And so is the case for countries, that they need two intellectual human resources and economic resources to push forward the legal claims against other countries. I would like to highlight one idea that I find particularly interesting in the book, and I think this idea, inadvertently by Professor Bahri, could travel well to other problem settings pertaining how, at large, the private sector or the civil society work with government to activate international mechanisms, actions, or global claims. That is the idea that the local interest of the industries concerned in a WTO law claim depends heavily on two variables. Firstly, the degree of self-awareness and organization of the players in that industry. And secondly, the regulation that fosters or inhibits the alliances between the technical areas in the government that will go through the WTO law challenge and the industry. The first variable means that, for example, in Brazil, China, India, it matters if a concerned sector of the industry can recognize itself as a group, and whether this group can recognize that there is a threat posed by a trade measure against the industry, and whether they can accumulate and put through a massive amount of information that is accurate, complete, and up-to-date, and that they can use that information to convey to governmental agencies in order to have an expected action from the government. Hence, the second variable. There should be an adequate regulation to capitalize what the private sector has to say to the government. These two variables have an explanatory potential well far away from the mere spheres of the WTO law. They can be employed to explain away why certain sectors of civil society can, or in which way they can enhance the request for governmental action, whether this is an interpretative reserve during a treaty negotiation, NAFTA is the case nowadays, a diplomatic note of étrangement, or to file a petition before an arbitration panel. This means that the book not only goes beyond an adequate diagnosis for its self-purpose of the explanation of this phenomena in WTO law, but I think the framework presented there can travel well to other forms of phenomena that need to be explained. That said, I also want to say that this book has to be contextualized within a certain era, that of multilateralism in international trade. I wonder now, and this is perhaps an open question for Professor Bahri, what can potentially be the role of the private sector when the state engages in the trend of private arbitration to solve disputes in international trade, such as the proposed mechanisms in the now amended TPP, or when a state gives in informal agreements with big players that promise infrastructure and credit, such as China. And here is the One Belt, One Road initiative. This is something to reflect on, something that I could not have reflected without the reading of the book. I finally would like to congratulate Professor Bahri for this work that I foresee as a valuable asset in the academia of WTO law. Thank you so much.
Thank you, Dr. Sergio. We now invite Licenciado Mateo to the podium for launching the book and presenting his initial comments. Licenciado Fernando Mateo y Venturini is an economy graduate from UNAM. He received a Master on Economy by El Colegio de Mexico and another Master on Economy by the Johns Hopkins University. He is the General Director of Evaluation of Economic Policies in the Ministry of Economy. From 2005 to 2016, Licenciado Mateo was the Mexican ambassador to the WTO. He was the president of the General Council of the WTO, of the Commerce of the Organization of Cooperation and Economic Developments Committee, and of the council that looks after the negotiations of services with the Doha Round. He has been a representative of Mexico to different international organizations such as well as locals. Licenciado Mateo is the author of a quarantine of articles about international economy and an expert arbitrator in the dispute settlement body of the WTO. Please welcome Licenciado Fernando de Mateo.
Let me start by saying that I'm really honored of being here today to launch the groundbreaking book of Amrita and to congratulate her. I must say that I read it, and you can see my wife says that I should go buy my books already underlined and then with an eraser start just taking away things that I think they're important. In any case, I enjoyed it very, very much. So I would encourage you first to buy the book and secondly to read it. And as I have been invited to officially launch the book, I do so and very much congratulate Amrita for her fantastic work. So it's launched. Well, in the introduction of the book, Amrita mentions that in the underlying argument of it is first that the participation problems should be addressed at domestic level, the participation problems of developing countries in the WTO. They should be addressed first at the domestic level. And second, that effective PPE arrangement can enable developing countries to mobilize resources at domestic level to better enable them to utilize the provisions of the WTO dispute settlement understanding. There have been many articles, books devoted to the participation of developing countries in the dispute settlement mechanism in the WTO. But really, this is the first one where this argument is introduced in such a way that provides a blueprint for developing countries of how to conduct these negotiations and to optimize the resources of both the state and the private sector. I believe that the way she does it, and that is to make a comparison between the mechanisms existing in the US, in the EU, in China, in India, and Brazil, is a way of doing things easy for the reader. And she spent 5 years in doing so, but I think they were very well spent 5 years, particularly for the reader. And this provides, as I say, a blueprint for developing countries, and I'm going to comment about this in a second, but for developing countries to try to find out how to optimize these kind of mechanisms. Let me start by saying that my first comment is, and I follow here Dr. Sergio in a different way. If Amrita had written the book today, I think that she would have devoted like at least half of its pages to try to explain what's going on in the WTO right now in the dispute settlement mechanism. We are in deep trouble, I must say, and we are in deep trouble because the dispute settlement mechanism is not working because of a misconception of some people and of some countries that have made that this very fine-tuned mechanism is not being used in a proper manner right now. And so that would be my first comment. My second comment is that that when the mechanism is not working and the protectionist forces are in full strength at the same time, we are between the rock and the hard rock and the wall. Well, wherever we're in trouble. So this is something that will make developing countries more interested in knowing how, in the face of, for instance, the proliferation of voluntary export restraints, how they had to negotiate to avoid these VRAs or to make the most out of it. My second comment is, Amrita, what didn't you included in your study Mexico? You live here, and Mexico is a very nice example of how the interaction between the private and the public sector works, and how it works. And I have here in the podium two big experts in WTO law, Mateo and Professor Gordon. So I believe that Mexico would have provided developing countries a good example of how things are done. My third comment is about all the work that you put in to trying to define what a developing country is. I mean, there is no way you can get out of that. It's been a big dispute in different fora trying to define what a developing country is. Singapore, is it a developing country or not? Singapore is a developing country in the WTO. Of course, with, yeah, sure. And Korea is a developed country, according to South Korea, the government, in industrial products, but not in agricultural products, and so on and so forth. I'm not going to go into this. And special and differential treatment, trying to include special and differential treatment in the dispute settlement mechanism. Mateo Diego was chairing what was called the off-campus group on dispute settlement in Geneva during many years. And of course, there's no way of including dispute settlement in this field. And finally, I must mention the inclusion in the book, Amrita, about member states. In the WTO, we're only members, because there are some that are, according to the WTO, are not states. And that has to do with, of course, Hong Kong and with Macau and with Chinese Taiwan. So let me just say that to conclude, that is a great book, that there are, as I say, a number of elements here that I could argue about. Well, for instance, when you say that India and particularly Brazil are export-oriented, open economies, I couldn't disagree more with you. I mean, Brazil is the closest economy. I don't know if North Korea is even closest, but the participation of imports and exports in the GDP of Brazil is 20%. Just to give you an idea, in Ireland it's 221%. In the case of Mexico, 75%, and you can go. Singapore is 200%.
It's 396 million.
I'm sorry, my mistake. So Brazil is not an open economy. India is not an open economy, but still they are very good examples of how the PPP partnership for WTO dispute settlement works, and really I congratulate you for you. Thank you very much.
Thank you, Licenciado. Now we will open all the panelists your books as a representation that we have initially and officially have launched Dr. Amrita's book. So if everyone could please open your books, and afterwards we will have a picture of all the panelists with their books. Thank you. Well, if you could get up and, like, make it a little bit more special, it would be amazing. Please put your book in front and smile for the picture. Thank you. Thank you very much. Thank you. You may sit down. We will now have our special connection through Skype with Professor Gregory Schaefer. Professor Schaefer is a leading authority on international trade law and law and globalization. His publications include 6 books and over 100 articles and books chapters on international trade law, global governance, and globalization impact on domestic regulation. His work is cross-disciplinary, addressing such topics as public-private networks and international trade litigation, comparative institutional approaches to trade social policies conflicts, and national regulation in global context. He practiced law in Paris for 7 years for Cadet Frere and Bredin Pratt, where he is a member of the Paris Bar. Professor Schaefer has served as Vice President of the American Society of International Law from 2014 to 2016. Professor Schaefer is on the board of editors of the American Journal of International Law and some others. We will now, what's happening? Is he leaving us? I don't think so. Let's call.
That's the video.
Okay, there we go.
Just stay here all night. So you can
I guess I hear I'm on. I can't see you. but I just received that message, so I'll presume that is correct. So I'm Gregory Schaefer. I'm very delighted to be here with you virtually. Thank you, Amrita, for including me in this wonderful celebration of the launch of your book. I'm sorry that I cannot be there, but I'm actually hosting someone here from my own center. It's a busy time of year, so I unfortunately can't be with you in person, and I wish I could see and hear you. It's a great pleasure for me to launch this discussion and remarks of appreciation for Amrita's book. The book represents for me a critical area of international trade law research. If law is to be legitimate, it must be broadly available to all members of the international trade law community. Formalized law is not sufficient. Formalized dispute settlement is not sufficient. Rather, as law and society scholars, of which Amrita is one, have long explained, that formalized law and formalized dispute settlement do not mean that right prevails over might, that reason prevails over power, as some have suggested in trumpeting the legalization of trade law with the WTO. Power rather manifests itself in new forms. Those able to wield the law are best positioned to make arguments to shape the law through interpretation, and are best able to enforce it through hiring and working with lawyers to bring claims. So once more in this situation, to quote a famous phrase from my former colleague Mark Galanter, the haves come out ahead. We thus, as scholars, have to look behind what formal rules to see how law operates in practice. We have to engage in socio-legal research with respect to the actors who actually face the challenges of what it means to develop legal capacity to bring claims. So early on in the early 2000s, I published my first book called Defending Interests, which, like Amrita's, assessed the law and action of WTO dispute settlement, but it focused on the United States and the European Union. And it asked, how do they mobilize resources through engaging with the private sector and lawyers hired by the private sector to bring WTO claims? And I concluded that book by asking the simple question, if the United States and the European Union depend on the assistance of the private sector and the private bar, what does this bode for developing country participation in the WTO system? Professor Bahri has taken up this challenge with her book. Her book is important because it gives voice to the experiences of those outside of the United States and Europe through a study of 3 emerging economies, Brazil, India, and China, who invested significant resources in building trade-related legal capacity in government, academia, the private sector, and the private bar. Professor Bahri studied this process through a research method that is too infrequently used in legal academia. She left the comfort of her office desk, and she traveled to meet with trade officials and trade practitioners from these countries to understand their challenges and experiences with the WTO legal system, the law in action. She draws from her original fieldwork, combined with the work of others, to explain how the WTO dispute settlement system actually operates in practice. Going further, she assesses what lessons might be learned, both for these countries and more generally for developing countries, who can learn from each other. She is, in short, an important rising voice for the empirical study of the practice of international economic law. Scholarship is a collective endeavor, and we're all proud to see Amrita's contribution to this growing field. Scholarship is a cumulative, never-ending process. It tests and verifies It renews what has come before. This work by Professor Bahri is a critical contribution to a corpus of scholarship that assesses the importance of building legal capacity for countries to become full participants in the WTO legal system. Only then can one envision it operating in a broader rule of law sense. As we all know, today the most important architect of the WTO system, the United States, is in open defiance of the WTO and broader trade law regime. It is an open defiance of WTO law by negotiating, currently, quotas in the form of voluntary export restraints to manage trade in violation of one of the key articles of the WTO system. And at the same time, negotiating tariffs that are above its tariff findings in its schedule to the WTO on a bilateral basis. They're not voluntary because, of course, countries are negotiating with a proverbial gun to their heads. The U.S., at the same time, is in open defiance of the WTO dispute settlement system by blocking the launch of the replacement process for appellate body members whose terms are expiring, possibly with the goal of seeing to the appellate body's demise. The U.S. is doing so because its administration has lost faith in the multilateral trading system, particularly in light of its economic rivalry with China. But as those in Mexico know, it is not just China that lies within the U.S. administration's sights. History, in short, is never ending. The hope of an international rule of law for trade is now under threat. Professor Bahri's work shows what can be done if countries invest in law and legal institutions. They now have a stake in the system. Let us hope that they can work together so that a vision of international cooperation and establishment of the rule of law for the regulation of international trade can prevail, or more modestly, at least has relative success compared to the alternatives. Professor Bahri's book is an important contribution during these difficult times. Thank you, Professor Bahri, for it. Since I cannot see or hear you, I will leave you now. Thank you once again, Amrita, for making it possible for me to offer my thoughts on this wonderful occasion. Thank you.
Okay, thank you very much, Professor. We now invite Professor Henry Gao to present his comments on the book and thank him again for coming all the way from Singapore. Henry Gao is an Associate Professor of Law at Singapore Management University. Professor Gao is also an advisor member of the WTO Chairs Program and the Asian WTO Research Network. He's a lecturer at the TMAS Foundation Center for Trade and Negotiations and on the training course on trade and investment integration. Professor Gao is also currently an advisor for the Asia Pacific Research Training Network and was a consultant at the World Bank. Please welcome Professor Henry Gao.
To start by thanking ITAM and Dean Sadu and Amrita, of course, for inviting me and hosting me for this book launch and also a seminar tomorrow. It's my pleasure to be in Mexico, a country that I only stepped in for the first time for this round. And I've been enjoying it very much, and notwithstanding all that I've seen from Hollywood movies. So I think probably I should make more trips to Mexico in the future. Now, Amrita and me, we have known each other since 5 years ago, since 2013, when she was still a research student at Birmingham. I recall receiving her email, but I couldn't reply in time because I was traveling at that time. So in her email, she was asking me to have an interview on PPP, public-private partnership in WTO disputes, because I have done some work in this regard, especially with regard to how China has tried to establish such partnership in trade disputes. So since then, we've known each other, and I'm glad to see that Amrita's work has proceeded very well and has culminated in the book that we see today. So congratulations, Amrita. Now, we also saw each other last year at the Law and Economics Institute in George Mason University in Washington, D.C. So I'm proud to say that I'm one of a handful of people in the world who have seen her work related to this book from the very beginning to the very end. Here I must apologize to Amrita's husband, Ankit, because as I was telling Ankit earlier, his name only appeared once in the book, in the dedications page, and my name is all over the place, and it's 50 times in the book. So I feel really sorry and awkward, but I hope you don't mind. Now, I think Amrita's work is a work of a great academic value. It is essential reading for students and scholars in this field, in this small field that we call WTO law, and especially with regard to public-private partnership in WTO disputes. It is a comprehensive study that compares the experience of several key developing countries in the WTO, including China, India, and Brazil. Now, as Amrita has illustrated in her book, these countries all face common problems. These include, for example, the lack of organization among the industries and the firms involved, the lack of coordination between the firms and the government, and also among the firms in industry, and even between the firms and the industry associations. But as she has nicely pointed out in her book, the approaches taken by different countries tend to be different when it comes to how to establish such a partnership. We see that, for example, some countries such as Brazil has a formalized institutional structure with a dedicated specialized dispute settlement unit that act as a kind of a link in the government to deal with these issues. We also see that countries like China, for example, that has established a formal procedure which is called the Trade Barrier Investigation Mechanism that is modeled after the Section 301 legislation in the US and also the Trade Barrier Regulation of the EU. We also see example like India, which does not have either an institutionalized mechanism or a formal legislation which grants the right to private firms to petition the government to take action against the foreign trade barriers. But somehow, all these different approaches worked well for each of the individual countries. So this book, I think, beyond the tremendous academic value, is also of a great practical value as well. Now, I have researched on WTO issues for 15 years, and I have also participated in some of the WTO disputes. So 15 years ago, I was working in the WTO Secretariat in the Trading Service Division, and the case I was working on was the Mexico Telecom case. I still remember that when I was part of the secretariat team assisting the panel in that case, we saw the Mexican delegation roaming around in the lobbies of the WTO secretariat very nervously, even though they had the backing of Telmex and Carlos Slim, who was at one point the richest person in the world. So if a case that is backed by the richest person in the world could get the governments nervous, then I would imagine for every other developed country, it could only be worse. Now, in her book, Amrita has discussed not only the theoretical points underlying the different approaches, but she has compared and synthesized the different approach. I think the last part of her book is really interesting, because this to me is essentially a manual to developing countries on how to design a dispute settlement mechanism. So by blending these three different approaches from three countries, Amrita has done a great job by helping developed countries in presenting to them the different models, which include, for example, the Chinese model, the Brazilian model, the Indian model, and now, after this book is out, the American model, which I'm sure is the best among the four models. Now, if developing countries follow her advice in the book, I'm sure that they would have a great success in establishing such partnership mechanisms. Now, I'm sorry to say this in front of Dean Sadiu, but I guess the next step for Amrita might be starting a consulting firm so as to help developing countries to establish public-private partnership in WTO disputes. Now, before the launch, I was told by someone in the audience, Mr. Federico, that my points should be pragmatic. I should give some pragmatic advice rather than just going on and on about all these boring academic points. So I will conclude my remarks with a very short and pragmatic advice, that is, buy the book. Thank you.
Thank you very much, Professor Gao, and thank you again for coming all the way to Mexico City. We now invite Licenciado Mateo Diego Fernández Andrade for more comments on the book. Licenciado Mateo is co-founder of Aegon Law Firm. He is a law graduate from ITAM and received a Master in International Relations by the Geneva School of Diplomacy and International Relations. He's also made postgraduates on financial law and international commerce, as well as in industrial and intellectual property law by Universidad Panamericana. He has specialized in compliance programs for Mexican enterprises, and he represents clients before the Federal Commission of Economic Competence. He was Director General of Legal Affairs in the Federal Commission of Competence from 2008 to 2013. He served as an advisor and a minister in the Mission of Mexico before the WTO. He is a member of arbitrations of the WIPO. Please welcome Licenciado Diego Fernández Andrade.
Muchas gracias. Let me start by apologizing because my English is very poor, but so is my Spanish, so I will make my comments in Spanish. First, thank you, Amrita, for inviting me. Thank you for Jorge for allowing this event to happen. I met Amrita less than a year and a half ago, when we came together with the crazy idea of organizing an event like this. And I was also impressed by her persistence, her way of trying to solve problems the best, the more practical and the quickest way. And so when I got the invitation, I knew that I was on for something very interesting. Let me start by saying that I must pay my respects to Amrita and to some extent express my envy. I spent 10 years in Geneva doing dispute settlement, and I was able to see some elements of these public-private partnerships take place. I saw how the Mexican delegation, in some cases, like the telecom cases, got together with private lawyers, with private firms, in order to try to build an argument, a defense for the case, and I saw other countries do the same. But I was never able to see patterns, to connect the dots the way that Amrita did. And she was able to organize and synthesize many things that passed before my eyes and that I could have never put in such an eloquent way as I did. I must also pay my respect for the discipline that she showed in organizing this book. Ambassador de Mateo said that it took her 5 years to complete, and I'm not surprised. If you take a look at the bibliography, it's 30 pages. Only reference to cases, to books, to papers, to interviews, and that takes a lot of nerve, a lot of time, a lot of patience, and being able not only to perform that task, but to put it in a way that it is comprehensible for the reader, el lector de a pie, as we would say in Spanish, is something that is very commendable. Like Ambassador de Mateo, I also have a complaint against Amrita. Why did you not talk about Mexico? I spent 10 years of my life trying to put Mexico in the map, but regardless of my efforts, actually in spite of my efforts, I think that Mexico is an important player. When you take a look at Amrita's book and you see the number of cases in which developing countries have been involved, you see that China has participated in 189 cases, India 170, Brazil 152, and Mexico 117. But if you look at the number of cases in which Mexico has been a complainant, you will see that Mexico has been a complainant 23 times, whereas China has been a complainant only 15 times. That may only mean that Mexico plays by the rules in a better way than China does, but it is something that, regardless of my personal bias, is something that I would recommend taking a look at. And I'm sure that living here in Mexico, Amrita has access to many of the negotiators, of the lawyers that have been that have had experience in not only WTO dispute settlement, but in the shaping of Mexico's international trading system in general. As for the substance of the book, there is something that if I had to describe the book in a few words, I would say this book is a snapshot. It shows the state of play of a phenomenon that has been evolving since the WTO came into form back in the mid-90s till today. What you see in the book may not be true in 5 years' time. You may have seen that things that Amrita says and that were true when the book was written may have changed. For example, Amrita talks about how the European Union deals with dispute settlement in the WTO. And what she says is that even though they are open to engaging with private lawyers in order to draft the arguments, it will be always the Commission representing the EU. Well, last year I was in a panel and the guy arguing for the European Commission was the guy from White & Case. It's something that surprised me, but that shows that things are changing. Mexico itself, when we started doing dispute settlement back in the late 90s, we were very close. We were only open to having government officials talking in Spanish always before the before the panel and the appellate body. And as time evolved and as cases became more complex, and when we were dealing with cases, again, like the telecom case or like the many anti-dumping cases that we had to deal with in the WTO, which are very specific to one company or to a small group of companies, you have to be more open to talking with the industry, with their lawyers, and there is always a tension, because as Amrita rightly points out, they have their interest, the government has its own, I don't know if interest is the right word, but the government has its way of doing things, and sometimes they are not the same. So there is a tension as what a company wants to achieve and what the government think it's right to say. For example, it is not uncommon that a company will challenge something, a particular, I'll take an anti-dumping calculation as an example, a particular way of calculating the dumping margin, but the government won't do that argument because they themselves do that. So it is always something to be taken on a case-by-case basis. It's not like you can do a one-size-fits-all approach. All cases have some artisanal part in their making. So my first suggestion to Amrita is take a look at this book in 5 years' time and do a comparison. And I hope it doesn't take you five more years, but it will be interesting to see how things have evolved. Of course, in 5 years' time, there might not be a WTO to talk about, but then again, that might be something in itself to talk about. What else could I say? I was interested to see that Amrita talks a lot about the importance of capacity building as part or as a result of these public-private partnerships. And I think that this is something that might be true for certain countries, for certain sectors, for certain types of players, but in others you will see countries that engage in a dispute every 5 to 10 years, or maybe just once or twice in their lifetime. Their interest is basically to get the job done. They don't need to train officials, because these officials, when the next dispute comes, may already be retired, may already be in a different posting, may already be in the private sector themselves. So in that respect, I think that
So I think that kind of empirical outreach research is really important in this day and age. And for the WTO, it's more important than ever to have this kind of outreach, because as we've heard from many speakers, the system is under attack. So I congratulate Amrita, and I'll just conclude by saying that I was pleased to hear all of the suggestions from our speakers today about future directions for her research to take, and I have no doubt that she'll be focusing a lot more effort on the Mexican perspective along with other developing countries' perspectives in the future. So thank you very much.
Thank you very much, Professor Bradley Condon. We will now have the author for comments on her book, Professor Amrita Bahri. Dr. Bahri is currently an assistant professor for international trade law at ITAM University. She's an international trade law scholar with the experience of practice, teaching, and research. She has a PhD in international trade law for the University of Birmingham and LLL in international business law from London School of Economics. She has published on the issue of international trade law, dispute settlement at WTO and developing countries. Dr. Bahri has practiced law in the field of international commercial arbitrations and civil liabilities with prestigious law firms including Fox and Mandel. She worked in the government of India in the Ministry of Commerce and Industry with private stockholders and the government on international trade-related matters including dispute settlements and anti-dumping investigations. Please welcome the author, Dr. Amrita.
Wow. I think after all the comments and applaud, it has finally started to sink in. It's here, I'm here, we're all here. My God, it's happening. I thank the panelists, my dear friends, my mentors, my boss, Professor Leo, for being here and being such an important part of my very special day. Well, a lot has already been said about the book and the content and the scope and questions I might be raising and answering in a book or an article that I'm working on in the future. So I would not be taking the discussion forward. However, I would want to comment and respond to Ambassador Fernando's and Mateo's, pretty much everyone's inquiry that why not Mexico? Why is Mexico missing from this book? So when I was writing this book, I spent most of my academic journey of this phase in the UK. And when I joined ITAM about 2 years ago, 2.5 years ago, time flies, I was very close to the finishing point. So all the research was already in, and I was working on the cosmetic part of it. So that's why, now that I'm in Mexico, you'll be pleased to know that I have just finished a book chapter wherein I explain how Mexico has treated non-market economies, mainly China, in anti-dumping investigations. It's going to be published by Stringers. And my next article actually is going to be about dispute settlement capacity building from Mexican perspective. So, Ambassador Fernando, I would be needing your help a lot because I do a lot of empirical research.
I have no idea.
This journey of 5 years, where I have tried to combine conceptual analysis with immense empirical research. I traveled to different parts of the world, many countries, met some wonderful people, gained their feedback, their practitioners' insight, the insiders' insight for the work. And in the process, in the journey, as you say, as they say, sometimes journey is more beautiful than the outcome. I cannot deny that the outcome is as beautiful as the journey this time. As I was going along in the journey, I met some wonderful people, made some great friends and some professional alliances. And the panel here is a testimony to that. It's an evidence to the amount of friendship and alliances I've formed during the journey of the writing and research phase of this book. I remember emailing Professor Henry Gao. I was doing my PhD. I was still in the first year. And Professor Henry Gao, my God, an authority on WTO law in Singapore. And I wanted to interview him because I was really inspired by his works. So I emailed him, Professor, I want to interview you. I have some curiosities that I want to address in my PhD thesis. No response. I wait. and wait, but he comes back in 3 weeks with a yes. And I get to interview him. And today he's here launching my book. Life is such. And I would also like to point out the beginning of my relationship with Professor Gregory Schaffer, who could not be with us here today, but we had the pleasure of listening to him briefly. So I was in my master's days back then. I was doing my LLM, and I got really inspired by his works. So I made a point that I would go to the conferences where Professor Gregory Schaffer comes. So I would go to the conferences and I would literally chase him. I would run behind him and he would go from one person to the other. Of course, he's quite busy when he's at the conference, a lot of demand. But I would literally chase him throughout the conference venue. And one fine day, I think it was the third conference, after so much of chasing, after 4 or 5 hours of chasing, he turned back and he's like, "Girl, what's wrong with you? What do you want?" I want to do research following your footsteps. And he has been a true mentor since that day. It's been 10 years, but he has mentored and guided my research work. So he's really the inspiration behind this research project. I came to ITAM when I was very close to finishing my book. But as some of us would know, sometimes finishing a research project that big and that complicated is more complicated than actually doing research and writing. So I came here at a very crucial stage. And I was new to the country, I was new to the city, I was new to this university, new to the culture, without a single word of Spanish in my vocabulary. And I was concerned whether I'll be able to work on my book and whether I'll be able to conclude it within the deadlines. But I would really like to thank from the bottom of my heart ITAM University, and especially our boss, Professor Jorge Sergio, who gave me the best possible environment, the perfect environment I could receive to be able to accomplish this project. Thank you, Professor. Thanks a lot. Sophia. So, as I said, I was here, no Spanish, no husband with me, he was still in London. He left me all by myself for 1 year. But Sophia really acted as an elder sister, taking me around on weekends, trying to make sure that I feel very comfortable in the city at ITAM. And since now, until now, she has been doing the same. So thank you for being there, Sophia. Brad, a true inspiration in the field of WTO law, a leading authority in the field of WTO law. It is a blessing to have him next to you. So we are neighbors, we don't share offices, thankfully. But my office is in front of Brad's office, and it has been a blessing to have him right there. Whenever I have needed him, as I was writing this book, I was giving the final touches. So thank you very much for being there, Brad. My students at ITAM, who accepted me in click of a second as a professor, and they made me feel as if I was at my own home in no time, with their immense enthusiasm and immense love towards me. So big thanks to my students. I can see a lot of faces from this semester and from the previous semesters being here. So thank you for your love. Emilio and Lorena, my two wonderful left and right hands. They are my research assistants, and they have really been contributing a lot in my research and teaching efforts. I would also like to thank my parents. They're not with us today. They could not travel all the way down to Mexico. But I would like to thank my dad, who is a law academic as well. He's a law professor, and he made sure that I come into academia and I join law. So he's really the reason as to why I'm here today. And my mother, who has spent many sleepless nights to keep me going. So she has really been the effort and the joy behind my life so far. Since my parents are not here, my other family, who has traveled a long distance, my brother Zubin, my sisters Ritu and Paru, who traveled from France and Canada to be here to share this joy with me. Thank you so much. And how can I forget Ankit, my dear husband.
I know you did.
I have to go home tonight. Who I mentioned as the love of my life.
Only once in the book.
Only once in the book, right. Professor Henry Gao takes the lead here. I will share a very interesting anecdote with you today. So, I was very close to finishing my book. 6 months, 8 months away. And I somehow convinced Ankit to try and read it. He said, okay, I'll read it. So he came back to me after 5 days, 5 long days, with his feedback. And he only had one sentence. He said, I don't like your research question. I think your research question is wrong.
Honest.
And you all know that I completely ignored his advice. If I would have taken his advice, we would not have been here enjoying this occasion. So, but jokes apart, without his ever encouraging support, without his intelligence, without his enthusiasm, without his love, I would not have been able to accomplish this. So, thanks a lot, my dear, for making it happen. And yes, finally, I would like to speak about the implications of the book. The book tries to voice the need for including developing countries, not just in the trading system, not just in the global trading system, but giving it the equal level for settlement of disputes as well. And without achieving that in developing world or developing countries, the rights that we get by way of WTO agreements are of no use, because there are no rights without remedies. It is a challenging time for the multilateral trade and dispute settlement in particular. With the recent developments in the US, Brexit in the UK, and such other developments that are following on, including the US blocking the reappointment and the appointment of appellate body members at the WTO. And I'm using that word again. The WTO dispute settlement body is being held hostage. So we are now facing a big threat. And that was precisely why I was in such a hurry to release my book, because all this was happening and I was like, oh my God, 5 years down my life and WTO may not be there, so who's going to read it? We're not going to have a book launch as well if WTO goes away. So I rushed and got it finalized. So thank God it's out. With all the hopes, I would like to conclude that multilateralism is not the only option, but is one of the most sustainable options to go for, that includes and that gives good inclusivity to the developing world. I'm actually falling short of words, so I think I would like to conclude here with a huge, huge thanks to all of you who are today with me, to share my joy, to share this very special moment of my life, of our life, and Kevin Man's life. So thank you once again for coming. There's cocktail following up. So I won't speak for long. Thanks a lot.
Thank you. Finally, we will have Doctora Sofia Charbel, who will present her vote of thanks. Dr. Charbel is a professor at ITAM's Law Department. She's a law graduate from ITAM and received a master's in legal sciences by the University Panamericana and a PhD in law by the University Panamericana. She has done legal research on regulation on the right to health protection. She has published several articles. She has been presented in an international scale. Dr. Charbel started the Law and Public Health program in Mexico. Please welcome Professor Sofia Charbel.
Good night, everybody. First of all, I want to apologize because I will be looking to my written words because I don't want to forget any of the names I have here. I'm very grateful, Amrita, for having been invited to give this vote of thanks. It really means a lot to me. This is a very special moment for all of us. For ITAM's Law Department too, because a new contribution has been made by Dr. Amrita Bahri to the commercial law field. It is also very important for Amrita, whose effort and tenacity is reflected in the book that has been discussed today. Amrita is a dedicated and enthusiastic teacher whose research and publications are part of her classes. The amount of time and work Amrita invested in this book is reflected in the content and future influence. We give special thanks and emphasize our gratitude to Professors Gregory Schaefer, that was here by Skype, to Professor Henry Gao, Licenciado Fernando de Mateo, Licenciado Mateo Diego Fernández, Professor Gabriel Gary, and Professor Bradley Condon for their comments and insight in such an important theme and for making this day possible. Special thanks to Dr. Jorge Sergio for the support he always gives the faculty and in this occasion to Amrita. Thank you all for being here. We also recognize the organization work of Emilio Castelló, who has also the benefit of being Amrita's research assistant, as well as Lorena. Of course, the work of Andrés Hernández Barrera has to be specially mentioned by editing the final manuscript. I've already thanked Amrita for inviting me to give the vote of thanks. I also want to thank her for being an incredible and honest colleague, but much more for being an exceptional friend with an incomprehensible handwriting that I just discovered, but with the greatest ideas and, as you all seen, with a very generous heart. With her, I have built a close friendship since she arrived to ITAM, and I'm sure that's the way it's going to be forever. With this book, Amrita leaves us wanting more. That's why I'm sure her future work, perhaps in Mexico, will ease our desire. Thank you so much, my dear friend, and congratulations.
Thank you, Professor Charbel, and all the panelists who have come and made this event possible. Thank you. Now our Dean and Head of Department, Dr. Sergio, will hand out a token of thanks to the panelists that have come all the way down here.
I think I already have this.
No, but they paid for the trip.
All right. Thank you all very much, the panelists and everyone who came here. This has been truly an honor hosting the event, and I've gotten the opportunity to be part of this mesmerizing event. Now I invite you all to join us for cocktails and some canapés. Thank you very much.